Morning, everybody. Welcome to the Social Service and Rehabilitation 2019 Committee. I'm try to be an efficient chairman, so I want to get started on time and finish early. So the committee will come to order. Clerk will call the roll. I just want to remind the members in the room this morning that everything we do is live streamed and recorded, so just be on your best behavior this morning. Today, just for those in the general audience, we're going to take up ABC bills today, foster care and corrections, as well as Family Care Act. Also want to tell you that as the former Daddy Daycare subcommittee chairman, when Senator Wagner was chairman, I've reviewed the subcommittee. An appointment as chairman now will be, I'm going to call him Granddaddy, Senator Cosgrove, since he just became a grandfather this year. So he'll be subcommittee chair for number 2. He's going to hear all the child care, child abuse, elder abuse. So if you're here to talk about or testify to that, you'll be doing that in his subcommittee, and he'll put out the information. Do you have that now when you're meeting, the first meeting of that, or working on that?
I believe it's Monday at 7:30.
Fifth floor, Monday,
Sorry, folks, it's the only time.
7:30 a.m. So with the committee's indulgence, I'm going to kind of go through a little bit of personal, get through some stuff that we can. I need to re-refer Senate Bill 1195, Senator Dance's bill, which is School-Based Health Centers Joint Task Force Report to Ed and Health, and I'll so move a motion. Okay, it's been motioned and seconded. Any discussion on that motion? Okay, the committee will vote. The second bill I need to re-refer is Senate Bill 1202, Senator Lucas, voting information for persons incarcerated in local corrections facility. That needs to go to P&E. I'll entertain a motion.
So moved.
It's been moved and seconded. Is there any discussion on that motion? The committee will vote. We've heard Senate Bill 1053. That had to do with parole. We sent that to courts, and I would also again entertain a motion to re-refer that one to Courts of Justice Committee. It's been moved and seconded. There's no discussion. The committee will vote. I need to take up Senate Bill 1245, which is my bill. It has to do with ABC agritourism. I'm making my own motion to strike that bill, but send it to the study that we are allotting ABC to have. Travis, so here's one more bill to add to the study. This summer I sent a letter to Travis taking all those type of bills into the study that we've requested ABC to take under. And so I'd like to make that motion to strike my bill. Do I have a second? It's been moved and seconded. Any discussion on striking my bill? Committee will vote. Okay. If I can bring your attention to Senate Bill 1140, that's Senator Favola's bill. It's identical to Senator Marston's bill 1085. At the request of both the patrons of that bill, I'm requesting to move 1140 into, roll it into 1085, list Senator Marston and Senator Favola as chief co-patrons, and then I'm going to ask that the bill go by for the day. So we'll take up the first motion to roll the two into one. It's been moved and seconded. Nobody against it. The committee will vote to do that. Okay, and as chairman, that'll go by for the day. Make sure I've got everything we need. Okay, looks like we have a sign-up sheet. Senator Carrico here. Senator Lucas here. All right, let's. Senator Peake, we can take up your bill first. Senator Peake, you have 1709. Okay, before you start, Senator Peake, let me just say a couple things that we did this summer. First, I want to thank my colleagues from this committee who spent countless hours this summer trying to hash out agreements on the ABC bill led by Senator DeSteff and the other members of the subcommittee worked tirelessly to get to some compromise. And I think for the rest of the members of the committee, you'll see some bills today that have been worked on where agreements have been made. Senator Peake, your bill runs in conflict to one of those Peace in the Valley bills today, but I'm happy to let your bill be heard if you want to go ahead and present that bill.
In that regard, then, Senator Reeves, could I pass this bill by for the week, see what your Peace in the Valley bill does, and then discuss it with the my constituent?
I don't have a problem with that. If you want to let it go by for the
That might be the best way.
week.
Let me see what y'all have agreed to, discuss it with my constituent, and then see how we want to proceed.
That'd be fine,
Save
without
everybody's
objection.
time to take a look. Thank you
Without
very much,
objection.
Mr. Chairman. All right, and members of the committee.
Senator Boysko, do you have a bill?
Yes, sir. It is SB 1644.
Committee will bring their attention to SB 1644.
Ready?
Yeah, yes, ma'am.
Okay,
Go ahead.
great. Mr. Chairman and members of the committee, today I present SB 1644, which would create a work group led by the Department of Behavioral Health and Developmental Services to develop a plan for sharing inmate health information between a community services board and a local and regional jails. To start, I have a line amendment on line 13 that would add the
Okay,
office.
hold on one second. Dave,
Yes.
you want to go with the line amendment?
Mr. Chair, the amendment is on line 13. After representatives of, insert the Office of Attorney General, and the amendment just adds a representative of the OAG to this work group.
Okay. Take a motion. It's been moved and seconded to accept the amendment. All those in favor say aye. Any opposed? Okay, now it's properly for us. Go ahead, Senator.
Okay, great. I brought this bill at the request of a constituent who is concerned that community services boards do not currently share information across jurisdictions. People with mental health diagnoses and treatment plans from one CSB sit untreated in jails in another jurisdiction. For example, a person who is treated by the Arlington County Community Services Boards may take a bus to Fairfax County where they commit a crime or experience a mental health crisis, and they are arrested and taken to jail. We are fortunate in Fairfax County that people are screened for mental health issues at the courthouse, and then a Fairfax County Community Services Board member may be brought in. The diagnosis and the treatment plan developed by the Arlington County CSB would not be available to either the Fairfax County CSB or to the jail. And people who are experiencing a mental health crisis are not always able or willing to share information about a current or a past treatment. While it would be advantageous to have that information, there are important health information privacy concerns, and this issue requires further discussion to determine a path forward. Mental Health America reports that there are 1.2 million individuals living with mental illness who are incarcerated each year, and often their involvement with the criminal justice system begins with low-level offenses like jaywalking, disorderly conduct, or trespassing. Studies show that approximately 26% of inmates were diagnosed with a mental health condition at some point during their lifetime, and a very small proportion, 18%, were taking medication for their conditions on admission to prison. Without intervention, the symptoms get worse and leading inmates to behave in disruptive and bizarre ways and become vulnerable to violence and to self-harm. Inmates whose symptoms are uncontrolled are also more likely to be confined in isolation or placed in restraints, and as a group contribute to the overcrowding of prisons and jails and the increased cost of corrections for both states and counties. The Department of Behavioral Health and Developmental Services will cover the cost of a work group with existing resources. They have representatives here today if there are questions. I want to thank the many people who have advocated for the people with mental illness and their families. I'm grateful for the work of NAMI, Mental Health America, and the other groups who provide critical support in times of crisis and recovery. I believe that this is a step we can take advantage of advances in technology and would make sharing of a diagnosis and a treatment information possible between Community Services Board. We don't know the solution for this today, and we respect the decision making and privacy for all people. This is a challenge for our jails and understanding what was going on with someone. Yes, sir.
Let me just tell you, I think you're in pretty good shape, and we have
Okay.
a very tight agenda.
Okay, cool.
This committee runs a little bit more efficiently than probably some of the others because we're on Friday mornings and we're squeezed.
Okay. Well, I hope
So
it's
do you
a
have any
pleasure.
witnesses wish to speak on behalf of your bill? Come on up, ma'am.
Good morning, Mr. Chairman, members of the committee. I'm Rhonda Thisson with NAMI, Virginia. We support the bill. Thank you.
Mr. Chairman, I move to report.
All right. Been moved and seconded. Is there any discussion on the bill? Anybody have any questions for the senator? Okay, seeing none, the committee will now vote. You're out of here.
Thank you.
Simple.
We told you you'd like the Senate better.
Okay, Senator Carrico, come on up. Committee will bring their attention to 1516.
Morning, Mr. Chairman.
Morning, Senator Carrico.
Mr. Chairman, this is dealing with the Department of Corrections and their disclosure of information of delivered controlled substance. This came to my attention. Within the Department of Corrections, they have individuals that do investigation in there. And in order for them to be able to track and keep information confidential and trying to keep them from letting some of these controlled substance in when they investigate inmates with that end up with these drugs, they need the ability within that agency through the direction of the director of the Department of Corrections to be able to investigate the employees, because a lot of times, unless you can track what medications the employees have been prescribed and how that drug is getting into the jails or prisons, you fail to be able to follow the lead whenever you're being whenever you're investigating some of these inmates that are in the prison. And unfortunately, right now they don't have that authority to investigate the employee and the prisoner. So this bill is directed to try to give them that authority to do so, for them to release that information, for them to be able to find out how these drugs are getting in and if they're coming in through an employee. I've talked to corrections and I think they understand now in concept what this is trying to do. I think that they do feel like there might be a little bit more clearer language that can be offered in this to make it more clear as to what they're authorizing to happen. So I'll just let you hear from them, and then we'll decide on how we move forward with that.
Okay, let's hear from the Department of Corrections. Step on up, sir.
Actually, I'm David Bryan. I'm the director of the Department of Health Professions, so I'm not from Department of Corrections.
I'm sorry.
But I do have some comments I'd like to offer. This bill came to our attention somewhat late, just because it was in this committee. It's not one we follow as closely. But basically what this bill, I think the intent of this bill is to allow the prescription monitoring program, which is my agency, to disclose to an investigator with the Department of Corrections when they have an active investigation to try to find out how drugs are getting into a system, into the prisons. Currently, you know, the prescription monitoring programs, I'm sure you all know, is a comprehensive database of all controlled substances dispensed in Virginia. And it's confidential patient information, but there are allowances for disclosure. So, for example, we can disclose to state police when they have an active investigation. We can disclose to our own investigators, but only when they have an active investigation. And as I understand it, this would extend to the Department of Corrections when they have an active investigation, the ability, you know, with that particular investigation, sure, to access prescription monitoring program. I do think that the language in here is awkward. It took me a little while to get really on top of what this was asking. But I discussed with the patron that we could work to tighten up language. We don't have a position on this bill, but I'm certainly willing to work with the patron to get the language to reflect what he's trying to get happening, and I'm happy to answer any questions about our side of it.
Any members have any question about the intent of the bill? Okay, Senator Carrico, do you want to get with my attorney and talk through that, or do you want to pass it by for till
Well,
the
I
next
didn't know
time?
how many, I didn't know how many meetings you had left. If you wanted to pass it by, I could get the language right, or if you wanted to pass.
I think we could probably pass it by since we've heard the bill, and then once we get the right language straight of what you want, I don't think we have to really belabor it. Is there anybody else in the audience which to speak to the bill? Okay. Senator Carrico, we'll pass it by for the
Yeah.
week and catch it on the next one, and then if you'll get with David, we'll make sure the language is straight, and I'll get it to the committee.
Yeah, we just clarify it so they know exactly who they're giving the information to.
Okay, you're good to go?
Okay.
All right, I don't see any more outside patrons. Let's start with inside patients, as my seatmate says. We've done that. Senator Sturtevant, you ready to go?
Yes, sir.
Okay, the committee will bring their attention to 1420. Let me advise the committee, if this is approved today, it's got to go to finance. You're up, sir.
Mr. Chairman, members of the committee, before you this morning is Senate Bill 1420. And this is a bill that creates a co-working establishment license that allows facilities with at least 25 members and offers shared office space to serve wine and beer to members on the licensed premises in very limited quantities. As you know, as our economy has changed over the last several years, there are less and less folks working in traditional office environments and more people who are entrepreneurs and freelancers and folks who don't work in a traditional office environment. And so these co-working establishments have really expanded all over the Commonwealth and around the country. This idea was brought to me by constituents who own and operate Gather, which is a co-working establishment. They now have several locations, both in the Richmond area and under construction in Hampton Roads as well. And it's something that more and more of our constituents are using, rather than, some folks work from home, some folks work in these co-working establishments, but this would essentially allow them to offer beer and wine limited to 2 servings to those who are members. And it would be limited to these co-working establishments that have 25 or more paying members on a monthly basis or an annual basis.
So are they currently operating now, the company you're talking about?
They are, yes.
Okay, and how are they operating, under what license?
They are operating in the sense that they are allowing people to
Individual.
come work there. It's my understanding that they are not able to serve beer and wine at this time.
Okay.
And that's why we're here today.
We have this study going on where we've spent the time, we're going to have ABC revamp a bunch of these specialized licenses. And I know the committee is, quite frankly, tired of the Christmas tree effect of multiple licenses. So, Travis, if you could step up just for a second, is this something you guys could absorb in the study, so we're not? Senator Sturman, I don't want to do any harm to your constituents that's asked you to carry the bill if they absolutely need the bill today, but I'd like to try to consolidate these under that.
Mr. Chairman, Travis Hill, CEO for Virginia ABC. We are aware of the bill. We've worked with the Senator's office in streamlining some of the provisions. We can do the will of the committee if you all would like to have it studied, or I think we can administer it. I think we continue to look at license fees and how the license fees are set to make sure we can properly enforce. I think our research is there's about 120 of these types of businesses in the Commonwealth, so it is, to the Senator's comments, a growing business. So we would just need to keep track of those expenses as we move forward.
Okay. So do any members of the committee have a? I'm sorry? Oh,
Okay, I'll make a motion when they're done.
okay. Go ahead, Scott.
So I think I have a question for Travis, I think. So assume somebody had a law firm in Fairfax with like 16 lawyers and about 20 employees, and they had a kegerator in their office. Do we have to have a license to do that? Because, I mean, this sounds to me like
I don't believe so, as long as you're not, those are all your employees, and that's a private space.
So what makes this different? Because they're not employees, they're renting to other people, so they,
Correct.
okay, thanks.
Okay,
What's your address?
okay. All right, anybody in the audience wants to speak to this bill?
Mr. Chairman,
Senator McDougal.
if we're, my question is the way this is written, not the individuals that Senator Sturtevant is trying to assist, but are we now creating a potential license that could create pop-up establishments? I mean, if I have a printer, a computer, and a fax machine, and I say you can come in and get you can be a member for a day, which there are a lot of different places that could do that, then you can bring 25 members and their guests can come in to this establishment that now serves alcohol. So I want to hear from Travis about whether, and no negative thought to what Senator Sturtevant is trying to do, but is the way this is written going to allow more possibilities than what Senator Sturtevant is trying to do?
Senator McDougal, we also had, in the initial draft of the bill, we had seen there was some of that concern. I think there's some limitations in terms they can only give away 2 glasses of beer, 2 glasses of wine. I think they're limited to 4 guests, and I think they've got to have at least 25 members before they can apply for this type of license. So there is a little bit more of an indicia that is a more permanent place than just stand up, be a member for a day, have alcohol, and then go away.
Mr. Chairman, I
Senator
might feel more comfortable if we had some sort of requirement that there at least be a time frame on establishment, that it not be, there's no prohibition if you got 25 individuals to sign up for it, you could move it around.
I think that could be an opening, yes, sir.
Go ahead. Do you want I think David has a comment.
Mr. Chair, I was just going to point out that if you look on line 184, there is one requirement that you have to have at least a 1-month membership, but that would be the only requirement as far as time goes.
Senator McDougal, are you good with that, or you want to?
Mr. Chairman, I don't know that it's the membership of the individuals as much as I'm concerned about as the establishment being able to, if you create this, there's a membership and have it in Northern Virginia, there's no prohibition of them opening a facility because they've gotten a license somewhere else because they have their 25 members and their members are more than a month. So that's not necessarily what.
Come on, Travis.
Mr. Chairman, Senator Sturtevant had asked me about licensing locations. Generally, how an ABC license works is we license that location. So a business model can't license, with one license 5 different locations. So you do have to license that specific area in order to obtain it.
Okay. All right. Let's hear from the folks behind you, Senator Sturtevant. I think there's, if you're for or against, just state if you're for or against it and who you are and why you're here.
We're for this. We are Doug and Polly White. We're the owners of Gather, the co-working space that Senator Sturtevant mentioned. Across the country, co-working spaces offer beer and wine to their members. It's a way of bringing people together and creating community.
Yes, we say we own a co-working community. Right now in Richmond, we have more than 500 members. We've been in operation for 5 years at this point. We are expanding right now into the Hampton Roads area and further in Virginia in the Richmond area. We anticipate at this time next year to the year after, say 18 months, we should have 1,500 members in just Gather. It is really a growing industry, and we give a home to a lot of small businesses, freelancers, entrepreneurs, and this is a way of bringing them together as a community.
As was mentioned earlier, if we were a company and the people that are members of our facility were our employees, we'd be able to offer them beer and wine with no problem. Large companies do that all the time. Because they're not our employees, but they're just members of our community, we need this license in order to be able to make that offer.
Okay.
Thank you.
Bill. Okay, anyone else wish to speak on the bill? Okay. At that point, Chairman will entertain a motion.
Move the report.
Second.
Okay, it's been moved and seconded to report the bill. Clerk will call roll.
Mr. Yep.
Thank the committee.
14-0. Good job.
Thank you, Mr. Chairman.
Senator Evan, come on up, sir.
Thank you. Senator and members of the committee, this is for Senate Bill 1498, and I understand the council has our line amendment.
David, you want to go through those?
It's on line 16, where it says avoid the use of isolation. It would now say minimize the need for isolation. Okay, so this bill has to do with youth detained at a detention center in Virginia, and particularly these minors who are under a federal contract. You may remember the articles this summer about the Shenandoah Valley Juvenile Justice Center. A good number of the kids who are there have been put there by the Commonwealth for allegation or conviction of a crime. Now, there are kids also there who are not been accused of any crime, convicted of any crime, and they're different than those convicted of a crime. They're not criminals. Many of them are fleeing gang violence or were sex trafficked into the U.S. They've gone through extreme trauma, some even mental illness from the circumstances they've been through. The evidence suggests that they are treated worse than other youth in the facility based on the articles this summer and other evidence we have studied. Despite not being convicted of a crime or they have an increased need for appropriate care. There's only one similar facility in the United States, in Yolo County, California, which had litigation against them. And part of this is we want to get best practices in place and avoid what could be expensive liability for the Commonwealth. There was a report from Secretary Moran's office about some of these practices that included restraint techniques, keeping records or having access to these records of these youth. Staff training for trauma-informed care were suggested in the report, and current issues with due process because of language barriers. And we know, of course, that every person in the detention center has a constitutional and legal right to due process. And former staff there have labeled the conditions as inhumane. And though the facts and abuse were outlined in Secretary Moran's report and in the former employees' report, or former employees' letters, the facts remain cloudy since they say that the records, particularly the videos, were destroyed by staff. And they weren't destroyed necessarily out of trying to avoid investigation, but they were destroyed in the course of things. And those who filed the complaints were no longer at the facility. So it was hard to make a really complete investigation. So what we're asking for in the bill is just to have the Department of Juvenile Justice set forth some regulations, and they're 1 through 7 in your bill, to review them and see, these kids, are they different? Do they need any kind of different things, whether it's dealing with language barrier or otherwise, mental health care, that sort of thing. Now, they recommended many of these regulations, or all of them, I think, in the bill, but none of them were required to be adopted. There was some question at the time about authority, and this is telling them you have the authority to adopt these regulations. I can talk to you further about how the bill regulations are needed because of evidence, but what I'd like to do first is bring up Ms. Lori Swain, a constituent who brought this to my attention. She has gone through hundreds of pages of federal and state documents, U.S. Senate report, the Secretary of Public Safety's report, and knows more about this than anyone I know. So if we could.
Great. Ms. Swain?
Members of the committee, thank you, Senator Eben. I'm Lori Swain, a 21-year resident of Virginia. Honored to be here around this issue. As Senator Eben mentioned, I track heavily on this issue. I heard of the Secretary's report, followed that, and I've read quite a bit of information about the Department of Juvenile Justice and its certification requirements. What I found through my study is that this whole issue is kind of like fitting a square peg into a round hole. For the past 10 years and expected long-term, facilities in Virginia built and certified to do one type of business are actually doing a second type of business, and they're not doing that really well. Being that that second business is caring for the well-being of children in their custody, this is very troubling for me. My point specifically pertain to Virginia certified juvenile detention centers that enter into third-party contracts and find themselves accepting children outside of their care experience and skills, and that these facilities are built to offer. These third-party contracts place 10 to 17-year-old children who have not been court-placed and have not been found guilty of any crime into a facility intended for a different population. These children have been found by the facility itself to be high trauma and often have severe mental health conditions. The facility acknowledges that it's not best equipped to currently support these children, but it tends to fall back on the contracting organization as being responsible for the problem, and the cycle continues and the children suffer. I agree that a remedy to this problem is a new set of certification requirements for such facilities entering into third-party contracts in Virginia, as Virginia currently doesn't have these certification requirements to assure the proper care and support needs of these children. The Shenandoah...
Senator Black.
I apologize for interrupting you, but can you clarify for me what we're talking about? I mean, can you define what is this group? Are we talking about, what are we talking about here?
These are kids that the Office of Refugee Resettlement has brought to Virginia. And like I said, they're kids who may have been sex trafficked. I have a nephew, in fact, who was my friend's adopted child, who was fleeing gangs in El Salvador. So they often go on to get full citizenship, but for now, they are under the category of refugees, and some of them don't have parents, which is why they're here. Those are the kids. They're refugees.
Mr. Chairman?
Senator McDougal, and then
Maybe somebody
Senator
from DJJ needs to come up. Why are Department of Juvenile Justice is established to for individuals who have been accused or found delinquent of criminal offenses. Why are we talking about something else altogether? So maybe we need to hear from them.
Good morning, Mr. Chairman, members of the committee. I'm James Toohey on behalf of the Department of Juvenile Justice. This is something that often happens even with the Department of Corrections when it's Department of Corrections or a local juvenile facility, such as in the case of Shenandoah, when they have available bed space. Oftentimes they contract out with the federal government who may need bed space. And it's almost like, a situation of renting bed space. It's through a separate contract, and it is, currently these are children that are there under the, under federal government control, not under, they're not Virginia children. But the local juvenile detention centers, in this case Shenandoah, does have the ability to contract with the federal government to basically rent out this bed space. Now, I will say that since this situation has arisen, the Department of the Juvenile Justice, through its State Board of Juvenile Justice, has begun to address this issue through the regulatory process. The board has already passed fast-track regulations that are intended to ensure that we have access to these federal children. I can read you just one brief paragraph.
Senator McDougal.
All that, I'm not sure I've heard the response to the question I was asking. Have any of these individuals been accused or found delinquent of a criminal offense? And if the answer to that is no, why are they in a Department of Juvenile Justice facility?
To my knowledge, they have not been, confused, judged, delinquent or convicted of a criminal offense. I'm not sure if they've been accused of it. I believe that some have, are believed to maybe be gang affiliated. But again, this is completely under federal control, and that's why the Department of Juvenile Justice did not have, authority over this situation. The board is currently changing that situation through the regulatory process to make sure that we have the authority to use our, certification authority to make sure that our regulations that are applicable to all Virginia kids are also applicable to these federal children.
Mr. Chairman?
Senator McDougal.
I just, when the regional jails and State Department of Corrections does have contractual arrangements with the federal government for housing of individuals who have been accused of crimes or committed crimes. And we know some famous ones have been held at a facility in my district because the media is always there to try to talk to them. So I have some concerns that at a state correctional facility, we're contracting for somebody that's not accused or committed of an offense. So that's a question I'm having a hard time overcoming.
Okay, let's go to Senator D-Step, and I'll go to Senator Favola. He's next in line.
While we're up here in the patron, so again, I'm a novice at this, but Department of Juvenile Justice is housing for folks who have committed a crime or accused of a crime. We're taking people and renting rooms to the federal government because maybe they don't want to put them in a hotel, but they've not been accused of a crime, they've not been convicted of a crime, there's no crime committed, and we're putting them in with criminals. So is this like Airbnb for jail beds because they're free? I can't quite get my head around what we're doing, putting people who are not criminals.
Oh, I'm
in
not
with criminals.
advocating it. I'm just trying to deal with the situation. And I
I
will
would go
say,
back to Department of Juvenile Justice. Why are we doing this? Is this within the scope of the law of your charter? If it is, then we have a bigger problem, but this doesn't seem right.
Mr. Chairman, members of the committee, and Senator, just to clarify, this is not the Department of Juvenile Justice. The Department of Juvenile Justice has control over our juvenile correctional facility. We regulate juvenile detention centers that are operated locally. This one is operated in Shenandoah. We only have regulatory oversight, and we can certify them to make sure that they're complying with the regulations. Our control is only under the State Juvenile Correctional Center.
Okay.
So it is like
So-
Airbnb. They can, if there's available rooms, they can rent them out to people or the federal government, and they can put non-criminals in with criminals.
Is that correct?
I mean, that would really be more of a question for the
Well, I
federal
see the folks
government.
behind you nodding their head.
Yeah, I mean,
So
I mean, are we putting good kids with bad kids? I guess that's the question the committee's trying to get answered. Is that true or not true?
well, I mean, I think that the children that are being placed here are being determined by the federal government to basically have to have a place to, house them while they figure out where they're going to place them.
That wasn't my question, sir. My question was, are we putting, as Senator D-Step said, kids who've committed no crime, aren't listed as MS-13 and everything else, with kids that have done that? That's the question.
I think the correct answer to that would be that there's probably a mix. I think that there are some that are viewed as being possibly gang affiliated, but that doesn't mean that all of them are. And so I think that it's a mixture.
Mr. Chairman, I just want to close with one last statement and question.
Go ahead.
So it sounds like we're taking refugees from the federal government that are not accused, have not been convicted of a crime, but somebody thinks, well, maybe there's a possibility they committed a crime or could be committing a crime or a possibility of. That's not how our system works. That's not how we work. And on the other side, we shouldn't be running an Airbnb of a juvenile detention facility. That's not how we work.
Okay,
So
Senator,
I think this is the wrong bill. I think the bill should be to prevent this from happening.
Mr. Chairman,
Senator Fable.
this is a really complicated issue, and I think Senator Eben is trying to find a solution within the current structure. The organizations that are operating these juvenile correctional facilities are local or regional detention centers, and we have not in the past prohibited these organizations from entering into contracts with the Office of Refugee Resettlement. So the question is, if these local and regional jails, not operated by the state, enter into these contracts, does the state have some obligation to ensure that there's a certain quality of care, if you will, or certain standards of operation? And unless we're going to have a heavy hand and totally dictate what the local and regional jails are going to do, I think we're trying to find a pathway forward so the state can actually create a regulatory framework to protect all of the children who are in the detention center, including those who are there because of a federal contract.
You got it. Senator Serval, you had a question, or can I bring the Deputy Secretary up first? You want to come on up and tell us what your boss is thinking?
Good morning. I'm J.K. Davenport, Deputy Secretary of Public Safety and Homeland Security. We have no position on the bill. I just want to clarify some of the questions that were raised. The local detention centers are not operated by DJJ. They certify the facility. And the local facility entered into the contract with the feds to house these undocumented migrant children. The reason why they're in a secured facility, and this is according to ORR that we found out during the investigation, is that they're deemed to be dangerous. Maybe they are perhaps members of MS-13 or something like that. So that's why they're in a secure facility. Other unaccompanied minors who are not deemed to be dangerous are sent to a different facility that is not secured. And so I think the question about whether, they're not charged with a crime and all of that, the feds have determined that there's some level of risk there. And they're being held there waiting for their immigration hearing. So I just wanted to clear that up, that it's not DJJ housing it, it's a local facility. We just regulate and certify those facilities.
Got it. Anybody else have a question?
If I might make two clarifications, sir.
Go ahead.
The kids who are there, what we've been able to find without record keeping is their danger to themselves, and that we know that some of them, at least, are fleeing from gangs. There may well be, as far as I know, there could be a kid in a gang, but we're asking for these regulations. The department said they were doing regulations, and the regulations would just be that when they certify a facility, that they would say if they're going to contract for these kinds of kids, the round square peg and the round hole kids, that they would look at these 7 categories and decide, are these kids just like the other kids, same regulation, or do they need language, or have they been traumatized? Are we going to meet those categories that would prevent us from exposure and make it so these children, if they are deemed to stay in this country as refugees, that they're not further traumatized by the system as they seem to be by being tied to chairs for long times and all kinds of other things I could document for you.
Hold on, Senator Black. Senator McPike, you had a question?
Mr. Chairman, my sense is of the committee that there's an underlying larger issue involved where we're housing kids in a jail that have not been accused of crime. And I think that's a fundamental flaw. I think this bill needs to be amended to say, to prohibit the lease of said facilities to where we're encountering a condition where we have kids that have not committed a crime but yet housed in this sort of scenario. I mean, I think there's some fundamental issues with that.
Okay.
I don't know if we...
Well, Mr. Chairman, my concern, I'm not concerned if we are housing MS-13 people. They're prior to trial. I mean, a lot of the people that we house have not been tried yet. But it does concern me that the Department of Juvenile Justice is not taking a position. And is there anything that prevents Department of Juvenile Justice from regulating in this area if they feel a need to do so? I'd ask the deputy chair, or anyway, someone from the.
Mr. Chairman, Senator Black, yes, we are currently in the board is currently in the process of amending our regulations. But in addition to that, back in September, we already put forth what's called fast-track regulations that go through the regulatory process faster. And if I could just read, one paragraph of that, it says, when a detention center enters into an agreement with a separate entity for the purpose of detaining a juvenile in the separate entity in its custody, the agreement shall provide that the program housing the juvenile shall be subject to, and then it mentions the regulation that allows us to oversee, govern the facility, the regulation governing the monitoring, approval, and certification of juvenile justice programs and facilities. And so in order to be certified, they have to be in compliance with our regulations that we put forward that we promulgate for juvenile detention centers. So even though the Department of Juvenile Justice only has operational control over the state juvenile correctional centers, we do have regulatory authority over the juvenile detention centers. And in addition to the fast-track ones that I just mentioned that passed in September by the board and that are now going through the process, we are now also in the process of amending our current juvenile detention center regulations. They've been discussed the last 3 meetings, and we're almost at the point of finalization. And so a lot of these issues are being addressed already through the regulatory process.
Mr. Chairman.
Okay, Senator Black.
So you don't really require any additional authority beyond what you have now, do you?
Well, currently we don't have well, there was a contract between Shenandoah County and the federal government. Already that contract has been amended to allow for access and monitoring of these children. And with the changes in the regulations, we would have the authority to have more oversight, to have access to these children, to monitor their treatment, and to have them fall under the same regulations as our Virginia children.
But you currently have
Senator Black.
the authority that you need, as I understand.
Well, and with the fast-track regulations, once they are finalized, then we would have the authority to be regulating them based upon those fast-track regulations, and that goes through a much quicker process than the regular regulations. Right now, they are in the last stage of the fast-track regulatory process.
Thank you.
Senator Evan, you want to wrap it up?
Yeah, and when DJJ came to my office yesterday, they told me that they're doing these regulations. Those regulations make and correct me if I'm wrong, no differentiation other than what he just said about the monitoring. They don't differentiate on points 1 through 7. What we're saying is if you're going to have these kids, look at points 1 through 7, and I can document instances in each of those cases why you would want to have them. Look at those and make regulation. If it's the same as the other kids, that's fine. But they told me that they want to have the same regulations for all youth. And they've had 10 years to treat them differently or better, or if it's appropriately. They need de-escalation techniques. They need psychological intervention sometimes. They need someone who speaks their language to tell them about their rights, if that's part of it. They need to be evaluated if they need mental health care. There are kids who are fleeing gang violence. There are some who could be in a gang or could have, but they have not documented that because the records have not been available. They're federal records. So I can go through 1 through 7 if you'd like, but
No,
in
we're
terms
pressed for
of
time, so.
okay, well, in terms of stopping it altogether, I don't know that that's going to happen, and I would like to see if they want to stop it altogether. I'm all for it, but these kids have to be somewhere, and if they're going to be in Virginia at this time, there's no reason that they can't review with the committee's requirement 1 through 7. They are different than the other kids.
Okay, thank you, Senator Evans. Okay. We're going to close discussion on that, and we're going to entertain a motion.
Mr. Chairman.
And it's got to go to finance.
There's no financial impact.
Mr. Chairman.
I'm sorry, hold on a second. Doesn't need to go to finance, but we need to adopt the amendment. So the amendment is before us. I have a motion to approve. It's been seconded. All those in favor of the amendment, say aye.
Aye.
Any opposed? Okay, now the bill is before us.
I move to.
Okay, it's been moved to report.
Mr. Chairman, after you take the motion.
Okay, and seconded, Senator McDougal.
Mr. Chairman, I just really think we're putting a lot of different things together in this regulation. I have some specific concerns about saying we're going to regulate a agency providing legal advice, which is what line 4 does, is providing legal advice to individuals who already have attorneys because they had to be appointed by somewhere else. I'd be significantly more in favor if we said this is a practice we want to stop, but I don't know that how we're going about it through this way is going to achieve the goal that I have concerns about.
Okay. All right. Committee's got the motion. I think you might have some changes coming your way, Senator Evans, from what it sounds like, but continue to work on it. So the committee will vote.
Mr. Chairman, I'd like to.
We're up, Bill.
7 yeas, 7 nays.
Okay, 7 yeas, 7 nays, the bill fails.
Thank you, Mr. Chairman.
Senator Lucas, come on up.
Good morning, Mr. Chairman, members of the committee. I want to begin by saying that this legislation is approved by the Joint Commission on Health.
Is your
and I
sen-
think you have a substitute in there. You have an amendment. And the next is substitute
David, you
in
got
Senate
it.
Bill 1273.
Give us 1 second, Senator.
Yes, substitute.
Okay, substitute's been moved. Is it seconded? All those in favor of the substitute say aye.
Aye.
Any opposed? Okay, the substitute's before us. Go ahead, Senator Lucas.
Yes, thank you, Mr. Chairman. In 2017, the Virginia Department of Corrections established a Central Continuous Quality Improvement, CQI, committee to better plan, coordinate, and monitor healthcare services in facilities department-wide in response to the Fluvanna Correctional Center for Women's class action lawsuit. That's what establishes this. The Virginia Department of Correction is currently phasing in duties and functions of the Central CQI Committee. This legislation makes the Central Committee a permanent part of the Virginia Department of Corrections Administration and requires its statewide quality CQI response and reports to be available on the public on the Virginia Department of Corrections website. And as I indicated, the friendly amendment substitute provides the department with a prerequisite time to continue phasing in the CQI committee and coordinating data for reporting purposes and for publishing the first quarterly report on the Virginia Department of Corrections website. The Virginia Department of Correction operates 39 facilities, prisons, work centers, and central offices, of which there are 5 infirmities. 15 medical services are being provided by the external organization, such as Armor, Inc., and there are also, of the 39, 24 services are provided by the Virginia Department of Corrections. 33 of the 39 facilities are accredited by the American Corrections Association, and VDOT is in the process of getting the 6 remaining facilities accredited. Accreditation, of course, will require each facility have their own CQI, keep getting twisted on that, program that includes quarterly reporting meetings of facilities' healthcare staff and the facilities administration. Meetings include a system of documented internal reviews of data, measures, and other healthcare services. Hoping my voice was gonna hold out. Sasslaw sneezed on me too much yesterday.
Senator Lucas,
Yes, sir.
there's quite a bit of people listed on here, and I'm not sure that I've ever seen some of these people, a dentist in the jail in my time in law enforcement, a pharmacist in the jail, some of these things. How are the departments supposed to pay for this?
Stephen? He's asking how the department's supposed to pay for it.
How are the jails
We're
supposed to
under
pay for it?
lawsuit, class action lawsuit, so I think we've got to find a way to pay for it.
Mr. Chairman, I'm Stephen Weiss, Senior Health Policy Advisor with the Joint Commission on Healthcare. And they're already doing all of these services, and they already have pharmacists around their system, and they have dentists around their system, if not hired by the department, then on contract to come in and do dental work for inmates. So all of this is already being done by the department.
So it's already being done?
Yes, sir.
Mr. Chairman?
Senator McDougal.
I think there's a little bit of a miss here. I think this is saying that they have to be employed. A lot of the individuals like pharmacists, just like we don't, many times we get pharmaceuticals that our doctor prescribes and they are dispensed by a pharmacist, but you might not actually talk to that pharmacist because it's being mailed to your house. And at DOs, at correctional facilities, that's oftentimes the way it occurs as well. A doctor makes a prescription, pharmacist dispenses that prescription, but the pharmacist is not directly having communication. So I think some of these, the list of individuals is not necessarily the concern, but it's being employed by the department could be the concern. If you contract out with a agency like we've contracted much of our healthcare as well, those individuals are not employed by Department of Corrections. They're employed by somebody else, but we have a contract with them.
Mr. Chairman, would employed or contracted cover that?
We have the medical director here who can respond to that, but keep in mind that we're on the class action lawsuit, and we're not gonna have much of an option anyway. So we've got to try to make it happen. So I want to.
Senator Lucas.
Yes, sir.
Based on my experience in the courts of justice, anytime we hear a bunch of those bills with all these attorneys and something's in litigation, we never pass a bill out because it's in litigation. I'm just telling you that, am I wrong, Senator McDougal, when I say that?
Mr. Chairman, I think this is a little different. This one is one where apparently we learned this last week, the attorney for the state did not file the witness list with the federal court, so when we went to trial in 2008, we had no witnesses because the federal judge would not allow them because of an error on behalf of our attorney, which was very concerning that we heard that. But be it as it may, now we're in a consent agreement based on that litigation for Fluvanna. And so we are going through that process now, and there are very specific items that consent agreement is requiring that we do. So with all that, I'm not sure what the bill is intended to do in regard to that consent agreement, because that's going to go forward regardless. I mean, Judge Moon has been very, specific and vociferous in his indication of what's going to occur under a court order. So I doubt that this is trying to achieve that goal. So maybe if we could understand what goal we're trying to achieve, could figure it out. But I don't have a concern from that litigation, because that's been resolved. There's an order in place. It's compliance with that order that we're doing now.
Yeah, Mr. Chairman, members of the committee, as I indicated earlier, this legislation was approved by the Joint Commission on Health, and I don't know that many of you here sit on that commission, but it was approved by the Joint Commission. Steve, would you like to?
Hi, I'm Stephen Herrick, Director of Health Services for Department of Corrections. This serves multiple purposes for our department. We do have a CQI committee that's statewide. which has those memberships on the committee currently. Those are our chiefs for the whole state, for the pharmacists and the other positions. It's become clear with the JLARC study and also the Pew Trust study that came out that Virginia is lacking in having a statewide CQI committee. So we don't oppose this bill. We would move forward with it anyway. I think this had a little bit to do with also having some transparency in what we do and what we present. But this committee is in existence now, and we are serving that function. It was driven faster by the Fluvanna case, but we were one of very few states in the country that did not have a solid CQI statewide process according to the Pew study. And then JLARC recommended it also.
Got it.
Mr. Chairman?
Mr. Chairman.
Can I ask?
Sure.
Doctor, do you, all these individuals, do you have a state governmental employee that would meet all that criteria? Or would you want some of the entities, I know we're contracting right now with 2 separate entities, would you maybe want one of those, an individual that's employed by one of those individuals, that one of those 2 entities that meets these qualifications? That's one of the questions I think Senator Mason and I had.
Currently, the model is that the CQI committee has those as state positions because we actually review the contractors. So it would be kind of a conflict of interest to have one of the major contractors on there. But your point is well taken in the sense that if things change in the future and we have difficulty recruiting those positions, it could be an individual contract with one of those individuals, which would be appropriate in that sense.
Mr. Chairman, maybe we need to have some language then that says healthcare professionals, if employed by the department, including, so we, well, maybe healthcare professionals employed by the department, if none are available, then contracted by the department.
you
Something
scribing?
along those
Employed or
those lines to make sure that, because as we're seeing, I guess 50% of our facilities are now under some sort of contract basis, and recruitment in certain areas is challenging.
We're in agreement that that will work.
Okay, so that's a friendly
I make
agreement.
that motion in
The
concept.
committee is in agreement with the overall intent of that. David, you can write that and scribe that? Okay. Does anybody else wish to speak to the bill? Okay. All right, it's been moved and seconded to report the bill as amended. Committee will vote.
Thank you, Mr. Chairman, members of the committee.
Thank you, Senator Lucas. Okay, we'll start taking up committee members' bills. Let's start with, you're tardy.
No, I've been here.
Senator Stanley.
Thank you. Good morning, Mr. Chairman.
Good morning.
Yes, it is.
Good morning, members of the committee.
What do you got for us, Senator Stanley?
Senate Bill 1064 is a bill that was sent to me by request. We have wineries in my area, and the winery owners that came to me said basically that, you know, they depend a lot on visitations to the wineries, but sometimes when they're coming in, and there may be a couple that comes in, one likes the wine and one doesn't like the wine.
Can you speak up a little, please?
Me speak up?
Yeah.
That's a new one.
I know.
Must be this. Talk longer and louder? Happy
No.
to do that. So basically, in the nutshell, these wineries came to me and just asked me to put in this legislation, which I obliged them, because when it comes to people visiting their winery, and of course they go to the tasting room, some spouses like wine and some don't. Some partners, you know, like beer and some don't. And so what this kind of does is trying to increase the opportunities of agritourism. And certainly we've seen some leveling off in terms of craft breweries here in the Commonwealth of Virginia. I mean, it was hot for a while, but it's kind of leveled off a bit. We still want to encourage that. And so when those people come in that go to a craft brew house, or those go into a winery, if they don't like wine, and then if we're selling a Virginia product beer, then they have that option. If they go into the brew house.
So, Senator Stanley?
Yeah.
So this is allowing places where they typically only do wine to now have beer and vice versa?
Oh, yeah, but it's all Virginia products, yes, sir.
Okay, all right. Anybody have any questions for Senator Stanley on the bill?
I didn't put liquor in it, I just want you to know. I just left it with-
Anybody wish to speak for or against the bill?
Mr. Chairman,
Senator McDougal.
just point out that we're, in everything that we're doing, we're just moving toward a system of anybody should be able to sell anything anywhere, at any time, in any manner that you want. Because now traditionally, we've done, breweries can sell things that they produce, distillers can sell things that they produce. We came up with a mechanism to do that. Farm wineries can sell things that they produce. And now when we're moving to things that you don't produce, it's opening up. So I just point that out.
Mr. Chairman, that's called liberty, freedom, America.
Cats and dogs.
But I anticipate that my
I see you have
seatmate always
someone
votes
standing
against my
behind
bills.
you. So, yes, ma'am, you want to step up?
Mr. Chair, Phyllis Arico from the Virginia Association of Counties, also speaking for the Virginia Municipal League. We oppose these bills. A lot of these provisions were very specifically crafted to promote the agricultural nature, but not create full-scale bars on these facilities. So we oppose this bill.
Okay, thank you. Tom, come on up.
Thank you, Mr. Chairman, members of the committee. Tom Lisk, representing the Virginia Restaurant, Lodging, and Travel Association. And we supported the efforts of craft brewers, of farm wineries to be able to sample their own products on their premises as a way of promoting those industries. But when you extend that privilege for them to sell products, other alcoholic products that they don't produce, you're turning these places into true bars without the same food requirements that restaurants. Any of these wineries, any of these breweries can put in a kitchen, they can serve food. Many of them do. Many of them have restaurant licenses that allow them to serve other alcoholic products other than the ones they produce. But to now start extending this to other alcohol products they don't produce creates an unfair competitive environment with restaurants. For that reason, we oppose the bill.
Thank you, Mr. Lisk. Mr. Hutchinson.
Ken Hutchison on behalf of Anheuser-Busch, and speaking on behalf of my colleague Stan Tradiak, who represents Miller Coors. We oppose this legislation. We appreciate that Senator Stanley wants to increase beer sales in Virginia, but don't appreciate the fact that products that are manufactured in Virginia by our two companies are excluded from his bill. Thank you.
Thank you. Yes, sir.
Mr. Chairman, members of the committee, Kyle Shreve with the Virginia Agribusiness Council. We do certainly appreciate the sentiment for Senator Stanley promoting farm and ag products. However, there are quite a few exemptions in the code, and it's something we are talking with ABC about in this study and hope to clarify some of those things. And so we don't want to jeopardize that and make sure an overall approach, comprehensive approach, rather than by piecemeal.
Gotcha.
Thank you.
Nice to stand on the fence. Yes, sir.
Jim Turpin, Virginia Wineries Association. We are opposed to this bill for two reasons. One, farm wineries are an agricultural enterprise, and we feel this would tend to cloud that issue. And secondly, there's already a process if somebody wanted to do this to obtain the two licenses. So this could be a duplication or eliminating something that's already there. Thank you.
Thank you, sir. Mr. Boykin?
Mr. Chairman, members of the committee, we appreciate what Senator Stanley's trying to do. However, on behalf of the Virginia beer wholesalers and the Virginia wine wholesalers, we have some serious concerns and associate our comments with previously stated presenters.
Thank you, sir. Senator Stanley, you want to wrap up before we take action?
Mr. Chairman, with all that love for my bill, I mean, how can I put it any better? I'm really appreciative of my friends behind me, and I understand their concerns.
Gotcha.
We are always asked on occasion to bring bills before these committees based on the needs of our constituents, and certainly.
And I
that's one of
appreciate
them.
you doing that.
One thing I will say is that being neither a wine drinker or a beer drinker, I certainly do believe that anything we can do to encourage those small business wineries and those small business ale houses, craft breweries, we need to do that in the Commonwealth of Virginia. We need to stop being backward thinkers when it comes to this kind of things. And I think Senator McDougall's comments are understood, but quite frankly, we need to do everything we can in the free market to help those farmers and agritourism. So that's my
Thank
position.
you, Senator Stanley.
Mr. Chairman?
Yes, sir.
Senator McDougall.
I think it's pretty momentous that a position I argued VML and VACO stood up and supported. So because I'm
There's been moved and seconded to gently, ever so gently, pass by indefinitely Senator Stanley's fine bill. Committee will, committee vote.
Mr. Chairman, can we also roll this concept into the study that we're going to do when we redo the licenses, and understanding that this does kind of violate the three-tiered structure?
Absolutely. Travis, rather than write another whole letter to you, can you add that to your list, please?
Mr. Chairman, that's the first time I've had a unanimous vote here at your committee, so I'm very proud of that.
Thanks, Senator Stanley. Senator Donovan, I know you're trying to get yourself together after delivering babies this morning, but I know you're focused. So if you're ready to go, the committee will bring their attention to, what's your bill number, ma'am? 1598. And if we support the bill, we have to send it to finance. And the briefer that you can be, the better you will favor, I'm sure. Okay, does anybody have any questions for Senator Donovan? Anybody wish to speak from any of the departments on the bill? Okay, it's been moved and seconded to report and re-refer the bill to finance. Committee vote. And like Flynn, you're out. Okay, we are now going to move to members' bills, and I know there are two identical bills. Senator McPike, you had a bill, and Senator McDougal, you had a bill that were identical. Senator McPike, you have the lower numbered bill, I think 1170. So do you two want to take that up or come to an agreement and roll them in?
Mr. Chairman,
Senator Cosgrove.
I would move that, sorry, I turn on my mic. I would move that we roll Senate Bill 1170 into Senator McDougal's bill 1726 and have them both chief co-patrons.
Second.
It's been moved and seconded to roll 1170 into 1726. You guys okay with that? Do you want to go the lower bill number? Are you fine with that too? You guys want to do rock, paper, scissors? I mean, we can figure it out. All right. Senator Cosgrove's made the motion. It's out there. The motion is to move 1170 into 1726. All those in favor say aye. Aye. Any opposed? All right. You guys batter up. Let's go.
Mr. Chairman, members of the committee,
Doesn't sound like he's on very good.
Mr. Chairman, members. Members of the committee, this is bill happy hour regulations. The keys to this is really lines 81 through 86. Basically, removing our current framework and regulatory framework that really prohibits restaurants from marketing anything in relation to happy hours other than to say we have a happy hour. And so this removes that requirement and allows on lines 82 through 84 the use of creative marketing techniques in such advertisements, and provides basically the flexibility as long as it doesn't induce overconsumption or consumption by minors. So in other words, we don't want to say get Slosh Saturday or come out all young ones to, basic common sense stuff. It provides those parameters, but it allows restaurants to be creative about how they want to advertise their business. And so that's the intent of the bill, and appreciate any questions. And I think we just want to double check we're carrying the same versions briefly, because I think there could be some difference.
Okay.
Mr. Chairman, I don't think we got to this, the reason for the bill because of the same reason. So I was unaware that there was another version floating out there. But there was, at one point, there was some litigation going through the process about what Virginia could
They couldn't do
restrict
on
and what
happy
it
hour.
could not restrict as far as conversations of happy hours, and that's what spurred me to try to make that clearer and put us in the, what I think is a correct posture, and that was how I came up with it. I think maybe a little different thought than what Senator McPike was going, but we
Same objective.
arrived at a similar conclusion.
David, hold on one second. Hold on one second, guys. David, are we in alignment with the two bills? They're identical. Okay. Senator Favolo, you have a question, then Senator DeStaff.
Broad term. Who would be regulating the creative marketing techniques? Who would make the judgment that they're either over the top or they promote overconsumption?
So
You have a lifeline through the attorney if you want to.
Whoever
Yeah,
chooses.
Mr. Chairman, and Senator Favola, when we were working through the drafting of this to identify, it's really the ABC Board of Regulations. David, you might be able to speak to it, but we had sort of this discussion. But we wanted to make sure that we are sending the message with this that folks can advertise and they can market their business.
I guess I have a follow-up question. So there
Senator
would be a
Favolo.
regulatory framework established for this?
Yeah, all of these still go through the ABC Board.
Yes.
And they'd create regulations, I guess, to help people implement this creative marketing?
Mr. Chairman, this really came about because there was a prohibition on any sort of advertising, and that was a First Amendment conversation. So what we've changed it now is out of that First Amendment conversation, allowing it to happen, but with certain parameters.
Conditions.
And but there is still a regulatory process that will occur. So we specifically, we're trying not to open it wide open so that you can
Right.
say anything, still allow some parameters, but those parameters have to be more narrowly tailored, and we were pretty much saying couldn't say anything before. Right.
Senator DeStaff.
Got it.
I just want to, I want to make sure I understand it, right? As I'm reading it, we can now allow pricing on the happy hour. So I can say Orange Crush's Friday happy hour from 5 to 7 for $5.
With this proposed language, yes.
Got it. I'm good with it.
Okay.
And I just wanted to clarify that, make sure I understood that.
It looks like you have some cheerleaders behind you. So I'll note who's behind you. Is there anybody opposed to this? Okay. Okay, it's been moved and properly seconded to report the bill. Is there any discussion at this point? Okay, please call the roll.
Do you have another one?
Okay, 14-0. Okay, Senator Cosgrove, if you'll take the helm, I'm going to try to get a few bills done. Senator Mason, as soon as I go, you'll be on deck for Family Care Act, and then Senator Cosgrove, I'll come back and we'll finish your bill.
Okay, thank you. Senator Reeves, what do you have for us?
Mr. Chairman, if it's all right with you, what I would like to do, actually, Mr. Chairman, can you hand me mine?
So he's going to do the local referendums. Wow.
Mr. Chairman, what I'd like to do is take up SB 1110.
All right.
Okay.
Mr. Chairman, this is part of the work of the subcommittee that we've been working all summer. It came out of the subcommittee, if I can remember the vote here. Five to one out of the subcommittee. I think Senator McDougal was the one no vote on it. But basically what this does is take, I think there's about 9 localities that we have, and it's actually, in talking with Travis, more like 30 separate municipalities out there that they're still trying to kind of get a gist on, if you can understand the technical aspects of that. Since Prohibition, making those dry counties wet and then allowing them the opportunity to referendum out of being wet. Mr. Chairman, the subcommittee heard testimony this summer on it. As far as I know, there's not any opposition to it. This would allow ABC the opportunity to establish stores in those jurisdictions. As we all know, that we've been talking about these issues for some time, that ABC's role in the capacity to help generate income for the state is greatly appreciated, and they'd like to encourage more of that, and this is a way to do that, to help use some of those funds for other areas. So that's the premise of the bill that came out of the subcommittee.
All right, thank you.
David asked the substitute that came through. After the subcommittee, we had a couple of amendments to the original bill. David, if you'll just go through those, that'd be great.
And can I get a motion on the substitute, please?
So moved.
It's been moved and seconded that we adopt the substitute to Senate Bill 1110. All those in favor, please say aye.
Aye.
Opposed, no. All right, the substitute is before us.
Yeah, David.
Mr. Chair, Senator Reeves. So there are three basic changes. The main change is that it puts the delayed enactment on the bills. This would give localities a year to go and have an anticipatory referendum in anticipation of this law taking effect. It also puts in an express provision in the enactments that allows such anticipatory referendums during that one-year period of delay and gives validity to such referendums. And then the final piece is that the last enactment that grandfathers prior referendums held by a locality, it puts a time limit on those of 5 years from the date on which the referendum was held.
Okay.
Mr. Chairman?
Yes.
Just one question. Is there anything that requires that the issue go to a referendum at all? Or does it just happen unless, unless the people rise up and call for a referendum?
Go ahead, Dave.
Senator Black, under the system of this bill, basically how it would work would be counties that are currently dry would go wet, and the locality would have the option to opt out by holding a referendum, as opposed to the current rules where in order to go wet, the locality has to hold a referendum.
And Senator Black, I can tell you, I haven't been contacted by any of them. And in fact, as there's been a movement afoot in Southwest Virginia where these counties are located, with the potential for gambling coming in some of those areas, one of the counties that would potentially house the golf course for one of these establishments is in a dry county, and I have not heard one peep from any of the counties. So I'm not saying that silence is consent, but so far we haven't had anybody come to us at all about it. And through the subcommittee and hearings and everything else we had, there was a consensus that this was a good thing to do.
All right, thank you. Any other questions to the patron? No? Okay. Is there? It's been moved and seconded to report the bill as substituted. All those in favor, please vote aye on the machine. All right. Mr. Chairman, the bill is passed 11-3. I'm sorry, that was your job.
Thank you, Mr. Chairman. Next, if we could take up Senate Bill 1242. Mr. Chairman, 1242 is the consensus bill. The same bill has already gone through the House process, is in its way to the floor, but this is the work of the product work of this summer as well. It allows mixed beverage license, restaurant license that specialize in high-end spirits to calculate for purposes of the food to beverage ratio gross receipts. The sale of mixed beverages by multiplying the liters of spirits sold by such licensee by the average price charged for 1 liter of spirits by mixed beverage restaurant license in the Commonwealth. This is the at the unanimous recommendation of the subcommittee, this is the bill that we've been talking about, that we've had Peace in the Valley on. And so, Mr. Chairman, barring any questions, I would ask that the bill pass, and unless you have specific questions for David.
Does anybody have questions? It's been moved and seconded, the bill passed. Before we take that vote, are there any questions of Senator Reeves on this bill? Is there anybody speaking in opposition to the bill?
Mr. Chairman, I have a question.
Okay. Senator Servo.
What is high-end spirits? I mean, I understand the concept, but like, that to me is kind of in the eye of the beholder. Like, you know, a $40 bottle of bourbon might be high-end to somebody, and I know there's probably $200 bottles out there too, and I'm not clear what that means.
Well, let's, David, can you answer that question?
Mr. Chair, so I guess the answer to that question would be on lines 149 through 152, where we set forth the criteria of determining whether a restaurant specializes in the sale of high-end spirits. So that the term high-end spirits is somewhat irrelevant in the sense of what's important is that you meet these factors in a high enough way to where ABC will consider you to specialize in the sale of high-end spirits. So, for example, one thing they look at is the average price of a drink that you're selling in your restaurant, the average price of the spirits that you're purchasing from the board, the average price of your inventory, and the seating capacity of your restaurant.
Thank you. All right. Opposition? Senator Reeves.
Oh. Go ahead. Mr. Chairman, members of the committee, David Skiles with the Vector Corporation representing the Restaurant Association of Metropolitan Washington. I want to first begin by thanking the ABC subcommittee for their work over the summer. I know there was a lot of effort put into this. Unfortunately, despite that work, RAMW is still concerned with the proposal before you. We are strongly in support of the existing food-liquor ratio. We recognize there are certain establishments that we're trying to get at. We're just concerned that the draft or the bill before you doesn't get at that. I do want to say one thing about the legislation that we are in support of. There is language in here regarding enforcement and giving ABC some additional tools to deny the sale of liquor to folks that fail to file their MBARs. That is something that RAMW is supportive of. We believe greater enforcement is necessary, and that's one tool that could get at it. But with respect to the proposal for mixed beverage licensees, that's something that we just can't support at this time.
Thank you.
Mr. Chairman, members of the committee, Miles Laurie on behalf of the Downtown Business Group. Just want to associate myself with Mr. Skiles' comments. Also, we really do support the
Thank you.
Chairman, Tom List, representing the Virginia Restaurant Lodging Travel Association. We too support the additional enforcement mechanism to make sure that the restaurants are not complying with their obligations to submit an MBAR report do lose the privilege of supplying spirits. And we appreciate the patrons' efforts to address the issue with high-end, high-price cocktails with some establishments that have difficulty meeting the food or beverage ratio. We support that concept. We're not sure this language exactly gets there, but appreciate that statement to try to address what we think is an issue that needs to be addressed.
All right, thank you.
Mr. Chairman, I have a question.
Senator Favola.
I'm just wondering, to the patron, there seems to be mixed reviews. You have a lot of kudos on the enforcement measure, but I guess the volume issue is still problematic. Would you be willing to carry the bill over for a week and try to work something out?
Senator Favola, Mr. Chairman, Senator Favola, I would tell you that we spent all summer doing that, and another week is not going to change the minds of some of the folks who are adamantly opposed to it. This was the recommendation unanimously out of the subcommittee to not be prejudicial against other business opportunities, but to find a way that we could have two licensing positions. So this provides that additional licensing ability for that. And then Senator Spruill had the recommendation of the 30 days. So we called that the Spruill Amendment, which we thought would help with the enforcement side, especially to kind of clamp that down. So I would tell you, I'd rather not pass it by for the week because I know it will go nowhere. after a full summer of doing this. So with all due respect, I would.
Mr. Chairman.
Senator McPike.
Mr. Chairman, I'd like to move to report the bill and speak to the motion.
All right, it's been moved and seconded. Please go ahead.
Just to follow up on Senator Reeves' comments, I did extensive outreach throughout Northern Virginia. I met with 4 chambers of commerce on this. While we did have some of the concerns that some of the members did express today, there was overwhelming support that we allow flexibility in this. And we have been through this all summer. We've heard this year over year. I have not seen a valid argument yet of how this would harm an existing business. I think we were very diligent to make sure we didn't upend the MBAR system itself. Thereby, we didn't impact existing restaurants. They're not having to change their point of sale system. So this does not cost any existing business any expense. Those who want to utilize this vehicle can. And so this is an available option with additional enforcement options. I think we've arrived at a place that addresses many of the struggles that this committee has faced over the years. And I've appreciated the feedback and willingness of all parties to discuss the issues. But I think we've arrived at a place that deals with some of the issues we've heard from business members that are innovating. And I don't see the harm to the other members in this process. So I do move to report.
All right, thank you very much. There's a motion properly
Chairman, I
seconded
have
to.
another question about the
Oh,
bill.
Senator Sorbel.
I saw in the enactment clause you want to exempt the regulations from the APA. I assume that's to try and speed things up. I'm not clear why the regulation process on this needs to be expedited as compared with normal regulations. So,
David, you want to address that?
I would probably recommend pulling up ABC on that one. I think they did need to get some things going in order to make sure that this new licensure scheme would be able to operate and come up with a system to make that work. But
Mr.
I'm
Hill,
going to let Travis hit it.
Enlighten us, please.
Travis Hill with Virginia ABC. I think the thought was we always struggle when these new concepts are passed and becomes effective in July to try to have the regs in place so people can start applying for the license. So I think the idea behind the fast tracking was to enable us to have those regs prepared and ready to go when folks wanted to apply for the license.
Senator Mason. Oh, I'm sorry. Senator Mason.
Thank you, Mr. Chairman. Mr. Hill, from line about 145 to 153, where we're drawing to the new specs, do you have any idea how many establishments would fall under that category at this point?
I would think it would be a limited number of licensees, given that the high-end definition, these licensees would have to comply, in order to get the license, would have had to have met the current ratio as well. So there are a handful of these business models, but I would not sense a large number.
Mr. Chairman, one more.
Sure.
Do you have any concern that those 6 lines blow the MBAR process up?
Blow the MBAR process
Or
up.
make, like, so you just said a very narrow group are going to qualify. Do you have any concern that we wake up one day and 35% of the restaurants in Virginia qualify?
That's not what we would anticipate at this time.
Thank you, sir.
Okay, we need to go ahead and move on. There is a motion that's properly seconded to report the bill. All those in favor, please vote aye. Opposed, no. All right. The bill passes 11 yea and 3 nay. Mr. Chairman.
Mr. Chairman, if it be the pleasure of the committee, I'd like to take up, because I know we're running out of time, I'd like to take up the foster care omnibus bill. That's 1339.
All right, committee will bring attention to Senate Bill 1339.
Mr. Chairman, this is the omnibus bill in relation to the JLARC report recommendations. Each of the committee members should have in front of them, Mr. Chairman, the actual printed copy of the JLARC report and a summary of all the different talking points with regard to the omnibus bill. So rather than belabor each of those points, those talking points, I gave them to you. So barring any questions, Mr. Chairman, I know there are some people that would like to speak for the bill, or at least note their support of the bill.
All right.
I don't believe there are any that are opposed. I know the administration is on board with the bill, and Senator Howell will be carrying the budget amendments for this bill.
Okay,
So-
why don't we hear from the folks that, who are in support of this bill? Very briefly, though, please. Good morning.
Good morning, Mr. Chairman and members of the committee. I am a single mom, a former faculty member of the University of Virginia, and the proud mother of an 11-year-old on the autism spectrum with a diagnosis of an autoimmune disease called PANDAS, which presents with neuropsychiatric issues that result from a strep infection. My son's father is a resident in another country and has never paid any child support or been in my son's life. Because of my son's health issues, I developed my own serious issues. I am now on Social Security disability, and I am indigent. My son was medically kidnapped by UVA Hospital and put into foster care. And I was found guilty of neglect after we were there for 48 hours, and I needed to drive from Charlottesville back to Midlothian to get my medication that I need for my own health and well-being. I was told by the nurse patient advocate that that was the best option. My son had a room attendant, and they would do an immediate TDO to get him into a state psych facility in Stanton. What ended up happening is
Ma'am, let me
they
interrupt
called suit.
very briefly. Are you speaking in favor of this bill?
I am, and
Okay.
I've only got 2 more paragraphs.
go
That's
ahead.
okay. Thank you. When my son was kidnapped by DSS, I was given a court-appointed attorney, and unfortunately, because I'm indigent, I don't have a zealous defense, and I have a rogue neophyte DSS worker who is abusing the process and her authority. This is all the more egregious due to the fact that there's no past history of abuse. Statute 16.1-2784, you can look up, but it talks about how removing a child from the home, you first need to look at putting services in place in the home. That was not done with me. What I am in support of, especially with this bill, is I allows the, in the foster care omnibus summary, allows the Commissioner of Social Services to develop and implement a corrective action plan for or assume temporary control over the foster care services of a local board of social services upon determining that that board has failed to provide foster care services and place or make placement and removal decisions in accordance with applicable laws. That's not happening. And 4, directs the department to develop and implement a more reliable, structured, comprehensive case review and quality improvement process to monitor and improve foster care services provided by local boards and departments of social services. Our situation is draconian, it is Gestapo, and it makes a Stephen King novel look like a happy musical. I am very much in support of this bill, and you might be seeing me in the future for other bills.
Thank you
for hearing me.
Yes, ma'am. Thank you. Yes, ma'am. Welcome.
Mr. Chairman, members of the committee, Allison Gilbreth with Voices for Virginia's Children, and we support this bill.
Thank you. Hello.
Mr. Chairman and members of the committee, I'm Valerie LaRue from Virginia Poverty Law Center, and we support this bill.
Thank you.
Mr. Chairman and members of the committee, I'm Cassie Cunningham with Children's Home Society, and we also support this bill.
Thank you. You look familiar.
Yeah, no, you're good.
I'm Janet Kelly, president of Virginia's Kids Belong, and if I look familiar, it's because I was Governor McDonald's Secretary of the Commonwealth. I've since left government to work in this space, and it's been 5 years. I'm not a policy expert like Allison and Valerie. I'm more of a practical expert as an adoptive mom and president of this organization. What I've learned in the last 5 years is that to say Virginia's system is broken is probably less accurate than to say it's full of holes like Swiss cheese. It's really great in some places, really bad in other places. And this bill will significantly help with those holes and fill those holes. We have so many organizations. We're getting ready to pump hundreds of thousands of dollars into Virginia to get more foster families into the system, which we think is the one domino that affects everything else. But it's not going to be nearly as effective if we don't have this kind of legislation. So please vote for this bill and vote for any bill that supports the system and improves it. Thank you.
very much.
And thank you. Mr.
Is there anybody
Chairman.
here to speak in opposition to the bill?
Mr. Chairman, I move that we report the bill.
All right, it's been moved. I'm sorry. Senator Favola, would you amend that to
gotta go to
report and
finance.
then go to finance, please?
I move that we report the bill and we refer it to finance.
All right, it's been moved and properly seconded that we report the bill and we refer to finance. Those in favor, please vote aye. Opposed, no. All right, 14 enough.
Mr. Chairman, I have a somewhat side bill that goes to foster care. It's a security freeze on the credit report. And I could briefly talk about that, but if we get into a law and dialogue on it, I'm afraid we'll run out of time, and I'd like to try to get through a few of these. There's one more ABC bill where there's harmony in the church on both sides of the chambers as well. But if I could briefly yield the podium to my colleague, Senator Mason, who has a second part of the foster care, at least a portion of that. This summer, I also appointed Senator Mason, who has done yeoman's work with regard to the Family Care Act that was sent down from Congress. And so he's been our lead for this committee in that, and he has some legislation he'd like to cover that helps with foster care.
Hi, Senator
Mr.
Mason.
Chairman.
Please.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. If we could take Senate Bill 1678 first.
All right.
So today, to work in childcare, you have to have a background check. But if it hasn't come through, you can start being employed, you can be training, you can be doing things that are not dealing with children. With the new federal regs, that's not the case any longer. So this is emergency to bring us up to spec with that you have to have a completed background check in order to start work at the facility. And that's 1678, Mr. Chairman.
I move the report.
Second.
So moved and properly seconded. Is there any comment from the committee? Anybody here speak in opposition? All right, seeing none. Those in favor, please vote aye.
Oh, could you hit me, please?
Scott.
Scott. Thank you, Mr. Chairman. Second,
Hold on a second.
Oops, my bad, I beg your pardon.
That bill
Excuse me,
passes.
ma'am, I'm sorry.
Please go
Thank you,
ahead.
Mr. Chairman. So this is the big deal. This is Senate Bill 1679. That is the work of the Families First three-branch of government effort throughout the course of the year. We have had over 110 stakeholders involved in this, countless hours of meetings, and tried to come up with a framework that deals with what is an exciting opportunity for us. The federal government has changed so that now we can put money and get matching funds toward prevention. So everybody in the industry is eager and excited. It's what we've been asking for forever. So up heretofore, you have to have a CPS report, and then you can start in with treatments and work and the efforts that need to be made. But the social services professionals will tell you that almost every situation is known to them in advance. Now we can put money towards prevention, but it has to be through evidence-based training, which is a very set group of criteria. This bill speaks to residential treatment facilities. So you've seen the recent report. There was a little concern for me about the residential report because we are under 16% of children in these residential facilities. So we do a pretty good job of trying to keep them out, but some children end up in these residential facilities. This bill walks through the new criteria that, and it is vast. We have 141 of these facilities, only 39 of them are accredited. Being fully accredited is but one requirement of the new qualified residential treatment facilities. So starting about line 171, we speak to, 175, we walk through the new requirements of these facilities, and it's a long list there. Then if you keep moving through to 252, it speaks to the documentation and reporting needed for foster care that Senator Reeves just worked through. If you go to 352, it lays out the hearing and the assessment reports that have to be done. The one thing I would like to point to your attention to that we might want to make sure we keep an eye on is on line 842. How about that? 842, and I'm just buzzing you through 500 lines. I apologize. But there's a family and permanency team. And I think that's a new definition that we've seen, but it's really an effort towards making sure that we include as many people associated to the child as possible. So this bill lays out the new requirements that will have to be met in order to be funded for a qualified residential treatment facility.
Okay, wow. It's a whale of a bill.
It's 1,000 pages in 3 minutes, sir.
Okay, any questions from members of the committee? Is anybody here to speak in opposition to this bill? Senator Favola.
A quick question, maybe for the patron.
Yes, ma'am.
How many facilities will actually be affected by this, and will they have time to meet these new requirements?
That's part of our, Mr. Chairman, Senator Vola, that's part of our problem is this ostensibly goes into effect in October of this year.
Yeah.
And we would then, and Carl can walk through, we would have to say, okay, here's our report and we're ready to go. There's some budget money, so I assume this has to go to finance as well. There's
Yes.
some budget money we asked for to look at those 39 that are at least accredited and see how many of those are close to being ready. But they will all have to qualify at some point. Once we put the plan into effect, in order to get matching funds from 4E and the federal government, they'll all have to qualify.
But there will be a process. I mean, they're not all
There
going to
is.
be qualified by October. You're going to start the process, and that's what this effective date means. Okay, my question's been answered,
Yes,
Mr.
ma'am.
Chairman.
Thank you.
Thank you.
And I would move that we report the bill and re-refer it to finance.
That's moved and properly seconded. They report the bill and we refer to finance. Anybody else want to speak? No opposition, right? Okay. All right, all those in favor, please vote aye.
Let me just thank,
Please,
go ahead, sorry.
close the roll, please. Mr. Chairman. Can you strike that roll, please?
It's all right, it's fine.
All right, that's fine.
Mr. Chairman, let me just thank the committee for two reasons. One, you put an enormous amount of trust in myself and the subcommittee this summer, as well as I put an enormous amount of trust in Senator Mason. You all have too. There's nobody better informed. So if you still have questions about some of the technical aspects of the Family Care Act, don't come to me, go see Senator Mason, because that's his baby, and he's got it. So thank you, Senator Mason, for handling all that. I know that was a ton of work. Mr. Chairman, I would like to probably take up, I think we have time to take up maybe one or two more bills if we can get them out of here.
Mr. Chairman, we go into session in 10 minutes, in 12 minutes, actually.
Mr. Chairman, let me try to get one more of these out of here. I think there's,
Mr. Chairman, I do have someone here also from several hours away to testify on something.
okay. If we could just take out the, where is it? Oh, it's the last ABC bill. It would be the last ABC bill I have. I'm trying to, 1668, Mr. Chairman. Members of the committee, 1668 is a negotiated bill between Distillers Association, and what it would do is also change Sunday store hours to 10 a.m., and it would allow the distillers to actually get a 20% return rather than 15. This bill has actually made it through the House process, or at least the committee process as well. Senator Peake's bill was the bill that we passed by for the week because it runs in conflict to this Peace in the Valley bill. But that's basically the bill, Mr. Chairman, and this was came out of the subcommittee as well. So Travis is here to speak on behalf of the bill if we need to hear from him, but that's the bill I'd like to try to get out today.
Okay. Is there any questions of the patron or of Mr. Hill?
Quick question.
Senator Black.
So right now, we do not allow Sunday sales, is that correct?
Mr. Chairman, we
1
do
o'clock, so-
allow Sunday sales. This would go, I think they're from 12 down to 10 a.m. 1 to 10, I'm sorry.
Okay, so we're doing it during church service.
Well, if you're Catholic, you go to church on Saturday night, so, you know.
I go to the 8:15, Mr. Chairman.
Doing the best, Senator, I can do, yeah.
All right.
Okay, are there any other questions of either the senator Okay, it's been asked that this bill, if it is reported, that it go to finance as well.
Yes, sir, Mr. Chairman. I forgot to mention that.
Is there a motion on the bill? It's been moved and seconded to report the bill and refer to finance. Those in favor, please say, or vote aye. Let's close roll. All right, there you go, Senator.
Thank you, Mr. Chairman. We'll,
Do mine next week.
you want to take your last bill? Yeah, he's got a witness. We can take it up.
All right, we'll bring our attention to 1171. That's going to be the last one for the day. Senator McPike.
Thank you, Mr. Chairman and members of the committee. Senate Bill 1171, what it does is it provides a framework for, much like we had the Community Lifestyle Center bill several years ago that passed this body. This one actually deals with allowing either local government, business improvement district, or nonprofit. The city of Manassas in my district, we have a historic downtown. They do First Fridays every month. This allows the same sort of context where you have restaurateurs, if they're selling within those areas, those cups can then go across that invisible line where the existing retailer has their license, so that license for the event itself is sort of extended. And so it has to be approved by the locality as well as coordinated with the ABC in terms of the permit, has the same parameters of the existing code section in terms of security that needs to be provided for such events. And I did some extensive outreach to many other localities as a part of the ABC subcommittee that are very interested in making sure our historic downtowns and other business improvement districts have this opportunity to engage. And this is limited to 12 events a year, much like a small festival type of atmosphere. So, Mr. Chairman, we do have one line amendment, and that is, David, do you want to read it real quick?
Mr. Chair, the amendment would be on line 144 after businesses, strike comma, but excluding any parking areas.
Aye. That is Bill. Happy to enter. We have do have one gentleman who has traveled early this morning to come down here, and just like to give him an opportunity.
Good morning. I'm Larry Ponzi. I'm a restaurant owner in Arlington, Alexandria. So I'm here to support the bill. I think it's great for the communities. It'll help the businesses, and it'll keep more revenue in Virginia.
Great, thank you. Mr. Lisk?
Very briefly, Tom Lisk, Virginia Restaurant Lodging Travel Association, we support the bill.
Okay. Hold on one second. Senator DeSteff.
Mr. Chairman, I was going to make a motion, but I think this needs to go to the study because this is adding another license, and I think this is a little more extensive than the conversation we've had on it today.
Mr. Chairman, I suggest we took action earlier on a similar thing. It will be rolled up in the study either way, but I think it's important context that folks are interested in moving forward with this. So.
Okay. So, all right, we have a motion report.
And I will second that motion.
And it's been seconded by Senator Favola. Any other discussion for the committee? And I'm just going to caveat, you're voting for it to go to finance. Okay?
Yep.
All right. Okay.
Okay, we're done.
16 yeas, 1 nay. Thank you, sir, for coming down. With that, the committee will rise. Thank you, guys. Dude, we got a lot done today.